And hey, everybody, welcome back to the Law and Crime Network. I'm Michael Bryant with you for the afternoon session. Thanks to Aaron Keller for setting things up so nicely here. Well, that is some critical testimony. So critical, in fact, that prior to trial, the defense did not want this witness on the stand. The defense brought a motion on behalf of their client saying, look, we don't want the medical examiner to testify in this case. That in itself is odd. The medical examiner doing the autopsy is a natural. But they didn't want her to testify because of the opinion that when Corey Jones was shot in the heart, he would have dropped almost immediately. You just heard her waffle a little bit, suggesting he could move a few feet, maybe just from the inertia, if he was in fact running at the time he was shot. But her opinion is he could never have covered the 140 feet that separates where the body was found and where his gun was found. Fascinating, critical testimony. Joining me right now is Pate, a criminal defense attorney who has been taking this all in, and I'm anxious to get your thoughts. First of all, Pate, thank you for joining me. I appreciate it. What do you think?
Well, obviously, this is important, critical evidence, because if the state can show that Mr. Jones was shot before he ran that distance, and in other words, that the officer didn't have any reasonable justification to shoot him at that point because he was no longer a threat, I think that's critical to proving the charges in this case and to showing this was not a self-defense situation. So I can understand the defense wanting to keep out that testimony, especially the opinion that she's able to give that if he's shot in the heart, he's effectively going to drop dead at that point and not carry on 100+ feet down the road.
And the prosecution's counter-argument that ultimately won the day was that I can stack up 20, 30, 40, 100 experts to say just the opposite. And there was a request for a Fry hearing to determine whether the opinion by Dr. Juiced is accepted in the appropriate scientific community. That didn't happen either. The judge ultimately just said, look, you have your witness. She's an expert. The defense will have a witness as an expert. They can battle it out. It will go to the weight of the testimony and the evidence. It will not go to whether they are admissible or not. So one quick question, too. Let me ask you this. Have you ever been involved in trying to exclude the medical examiner from a murder case or an assault case, an injury case?
No, not the medical examiner. If that examiner is just going to testify to their examination, in other words, the autopsy and the cause of death. But what's happening here is the state's using their medical examiner for an additional area of expertise, and that is how far a person can run after being shot. So I can understand why they did it. It's a little bit outside the scope of a normal ME's testimony, so it's unusual but not unheard of.
Yeah, and it is obviously critical information for them. And they've now, cloaked this effectively percipient expert, the medical examiner, with the aura of expertise on a totally different and very important issue. Thank you very much, Pate. We will be chatting as we move through the afternoon. Let's take a quick break so we can get right back into that courtroom in Florida. We'll be back. Has just completed their direct examination of this witness, the ME, and looks like, as we pivot to the seal of the great state of Florida there, that there's a bit of a break now as the defense gets ready to cross-examine this witness. I can imagine, and let me ask you, Pate, based on the fight they had before the trial, I can imagine that the defense is going to kind of lay the groundwork at this point to dispute this expert's opinion that, the defendant, after firing that shot, would have seen or would have caused the victim to just drop in his tracks. What would you expect?
Right. That's got to be the focus of the cross-examination. I mean, there's no question in this case that the officer shot Mr. Jones and Mr. Jones died as a result of at least one of those shots. So the focus here for the state and now for the defense is going to be, what does that mean for the officer's theory of how this happened? And I think this expert gave a lot of leeway or a lot of room for the defense to maneuver when she kind of, I wouldn't say walked back her opinion, but
I think she waffled a little bit there, yeah.
She waffled a little bit, right. There's an opening there to suggest, look, you said first a few feet, then maybe a couple of yards, and then there have been cases where people have been able to run a couple of blocks. Bottom line is, you don't know that he dropped dead the moment that he was shot. So I think the defense has to do enough just to keep the possibility of the officer's theory of what happened alive at this point.
Yeah, we've seen this before with experts, and it's always, it concerns me when an expert is adamant and won't change an opinion and uses words like impossible and no way. I at least give this expert credit for acknowledging there is the possibility of something beyond her ultimate opinion, right?
Right, but that's why experts normally don't want to do that, because they know as an advocate, or at least the side that called them or is paying them or what have you, they want them to be firm because they're trying to make a point that's going to be important in the case as it draws out and certainly down in closing arguments. So, most good, competent, credible experts will not be absolute in their opinions. But then again, that's fodder for cross-examination.
Right. Let me ask you a question that deals with how you would handle the two charges in this case, because it's almost as if two potential crimes took place. There was the initial interaction where 3 shots were fired, then there's a 10-second gap, then there's the subsequent 3 shots, which appear to be one of those 3 took him out by hitting him in the heart. Corey Jones went down at that point. So we have an attempted murder in the first-degree charge, and we have a manslaughter charge. How, as a defense attorney, would you attack both of those charges, and where do you see your best result?
Well, I think the state did it that way to give them the opportunity to have the jury either make a compromise on one charge versus the other, or just to kind of see how the evidence played out. It's not the defense's responsibility to lay out a theory as to how this happened. The state has to show beyond a reasonable doubt that this officer killed Mr. Jones and did it in a criminal manner. So what I would do as a defense lawyer is see how the evidence plays out. Is the stronger argument for the state that he intended to kill him and had no justification at all? Or is it a stronger argument that this was a reckless or negligent situation where the officer was not following proper protocol and Mr. Jones unfortunately ended up dying? So I would sit back and wait at this point. I wouldn't make a decision about how to attack each charge.
Okay, I'm not going to let you wait. I'm going to ask you right now. We know that the state is close to resting. We think they're winding things down, and this may be their last witness. And we don't know yet for sure whether the defendant will take the stand. But knowing the facts as you know them, knowing how the events unfolded that night, what do you think your best defensive strategy is?
Well, I'll say this. I don't think we really know how the events unfolded that night, right? I mean, the officer has one version of what happened. The recording that we've heard of the phone calls, I think, suggests something totally different. Mr. Jones is not with us. He can't testify as to what happened. There's no other witness on the scene. So there's a legitimate argument about who knows what happened precisely and when it happened that night. But here's the thing about representing law enforcement officers, and I've done this many times. The jury is going to be predisposed to believe that officer because they know it's a tough job. You're put in a situation, you walk up on somebody in the evening, you think it may be a robbery situation. They give a lot of leeway to cops in excessive use of force cases. So you've got that presumption riding with you. So I think the best strategy for the defense lawyers to show, look, he may not have followed proper protocol, but he did not show up that evening to try to murder anyone. He was trying to do the best job he could. He may have made some mistakes, but this is not a murder. And this is not manslaughter. And
I talked about it on Friday when we were going through the tape that the officer put together as far as his informal interview, his walking through the scene of the crime. My position was this jury's got to get in his shoes. They've got to feel what he felt that night for at least one of the 6 to say, look, how did he even handle it as well as he did, as opposed to this guy was looking for a fight and he effectively executed the guy. So I think you're right. I think they have to figure out that as a cop, it's a tough job. They're glad they're not doing it and give him the benefit of that doubt, right?
Right, and we see that with juries. I mean, it is incredibly difficult to convict a law enforcement officer in one of these shooting cases. I mean, we hear on the news about, the high-profile ones and the occasional convictions, but they are rare. And in fact, it's rare to even charge an officer in this situation. I think it happened here because the officer's statement was simply inconsistent with the evidence. And so that gave prosecutors at least enough as far as probable cause to move forward with the indictment.
So they're on a break in this Florida versus Nouman Raja case out of Palm Beach Gardens and Palm Beach County. So we're going to take a quick break. You won't miss a thing. We will come back to more on the Law and Crime Network. And so it begins, the tearing down of the expert by the defense there. That's Richard Lubin, the defense attorney. He's got the autopsy report. Basically, he's saying, so in all of your autopsies, how many mistakes do you normally make? Is this 3 or 4 that I've pointed out so far? Is that more than usual? How many mistakes do you make in a given day? I think it's important, Paige Pate is with me, criminal defense attorney out of Atlanta. I think it's important, Paige, that early on in her direct testimony, she talked about how many autopsies she's done and how many she might do in a year. And, I'm no math major, but it came out to like 1 every day or so. So this is kind of easy to point out little discrepancies in a report, don't you think?
Absolutely. I mean, that's clearly a very busy office where she's going to go through a number of autopsies in a given week and generally not expecting to testify at a murder trial for really any of those autopsies. As you know, most cases, even if there is a murder, rarely go to trial. I mean, it's the exception where we see the case played out in court. And what the defense is doing here, and it's great strategy, is to pick up on the little mistakes. And yeah, at the end of the day, these mistakes shouldn't change your opinion, but the jury gets the message that she's sloppy. And that's concerning because the jury may not understand all the science or all the medicine, but they understand dotting your I's and crossing your T's. And if the defense can show she didn't do that for the simple stuff, they're going to have questions about her ultimate opinions.
No doubt about it. And I'm thinking as I listen to her, you know, these reports are generally dictated and then given to a stenographer, somebody who takes the dictation and types it up. You know, she has an accent. It's very possible that a word is misheard or misinterpreted by the person transcribing and comes out innocently enough on the report. But now, of course, the defense counsel's plan is to make it look not so innocent. Okay, we're going to come back to that courtroom in Florida in just a couple of moments. More with the doctor on the stand being cross-examined. We'll be right back. Well, Dr. Juste has a certain, I'm not a dialectician, sounds like a French accent. She has a very c'est la vie sort of attitude about things. She's being challenged by this defense attorney for the officer being charged with these crimes, manslaughter and first-degree attempted murder, and challenging him, saying, I'm not going to say this might happen, this might happen, this might happen. You give me a various hypothesis, and then I'll tell you whether or not the facts fit that hypothesis. Paige, let me ask you, we've talked about the substance of her testimony. How do you like her style?
I don't think she's doing well at all. I don't think the jury's able to relate to her as a person. I think generally when you put an expert on the stand, you want someone who's going to come across as a professor, someone who's going to teach the jury about the medicine, about the science, someone who's going to be relatable. I don't think we're seeing that from this expert. And I think what we're seeing is a risk that the prosecutor should have known that they were taking with a witness like this. If you're going to call a witness who's going to have an expert opinion that's going to refute part of the defense's theory, then you better be right, because now you've taken on this obligation to prove something you didn't necessarily have to prove. You could have just focused on the inconsistencies in the officer's testimony. But now they've put this witness up, and so for every hole that the defense makes in this part of their argument, it's going to hurt their case at the end of the day, their entire case in the theory of the prosecution.
And they've definitely laid the groundwork for the crux of the argument, which is this guy could have run 10, 20, 30 yards after being shot. That is going to be played out huge in closing arguments. We're going to take a quick break. I'll be back with Paige, and we'll talk more about this case out of Florida. This is the Nouman Rajah case. Don't forget tonight, Aaron Keller and the Daily Debrief coming up at 5 o'clock. Come right back here. We'll pick up things in that Florida courtroom. More on the Law and Crime Network coming up in just a moment. That is the medical examiner, Dr. Gertrude Juste, being direct examined, trying to rehabilitate the witness, the prosecution there. I think the prosecution wanted a very simple, yes, that's right, answer when re-asked about the victim just basically stopping in his tracks at the moment that his heart was blown apart by that gunshot. Didn't quite get the you're actually right short answer. Paige Pate is with me. Paige, first of all, any change in your opinion on this witness? Do you still think she's a little sketchy? What do you think?
Well, I actually think she's doing a much better job on redirect. The prosecutors, you're right, I think we're trying to focus her on getting those yes or no answers. But what she did was even more effective than that. I mean, she turned to the jury, she explained the reason for her opinion, and even more importantly, put it in layman's terms. Have you ever experienced low blood pressure? Then you know what I'm talking about. That can be very effective to a jury who's just hearing a lot of scientific and medical testimony that may go over their head. So I think she's doing a lot better now and is going to leave this jury with a better impression than when she was crossed.
It looks like she's leaving the stand now. I'll tell you one thing, and this is to me as important for a witness, an expert, a defendant. She's likable. You know, she's just, you know, seems like, you know, she's doing her best, trying to do her job. She's likable. I think that's important.
Right. I mean, she's not like a paid expert coming in from out of town who's going to opine and say whatever that lawyer or that side wants him to say. I mean, she works for the state. She's a medical examiner. She's done countless number of autopsies. And I think it is clear that she believes what she's saying. I mean, people may have a little bit of trouble understanding everything she says because of the language difficulty or accent, but she absolutely believes what she's saying, and I think that comes across.
She's definitely passionate, no doubt about it. Well, we thought this might be the case when that witness left the stand. It might be the last witness for the state, and matter of fact, that is what has happened. The state has rested in Florida versus Nouman Raja, and they're going to take a break. And once again, I see the lovely seal of Florida in the camera's eye there. So we'll find out whether the defense is going to start their case for the day. My guess is they might just say, let's wrap it up and, come back first thing fresh in the morning. But we'll find out for sure in just a couple of moments when we come back to the Law and Crime Network. This is Mr. Frank Piazza. He is a forensic expert in a very finite category, audio-visual skills. So he has taken the tape that we have heard many times from the AT&T operator, roadside assistance operator, and he has looked at it not just from the point where we hear the first recognizable sound, which appears to be Corey Jones saying, huh? But he's looked back at a time period before that. Now, Pate is with me, defense attorney out of Atlanta, and we know how critical this is, Paige, because huh is not something you say unless somebody has directed a question or made a statement to you, right? So the real question becomes, can this witness tell us what, if anything, he deciphered from that tape before we hear huh?
Right. I think it's important, or at least the defense feels it's very important, to show that what the state is saying is on this tape is not everything that was said at the scene. And so that may give more credence to the officer's version of how these events unfolded that day.
So I think common sense would tell you, you don't say huh unless you almost heard something or you're responding to something. So that's great. I don't know that he needs to reinforce that point. But if he can come up with something in the way of context or actual words said prior to the huh, well, then this guy's worth a fortune to the defense, right?
Right. I don't know if we're going to get there. Obviously, they're kind of going through his background, what he did to analyze the tape and the recording, the enhanced version, and perhaps the state in rebuttal will call an expert to say this guy's just full of it. We don't know what he's talking about. But I think at the end of the day, if the defense is actually going to do something with this testimony, they're going to have to clarify what was said, because you're right. I mean, obviously something happened before the huh, but what was said? Was the officer giving very specific instructions, identifying himself? Because that seems to be a big issue in the case. That's
huge, yeah. And if he does something and enhances it and I hear "Turn me on, dead man," then I know it's a whole different matter. Okay, Pate, thank you so much for joining me this afternoon. I know you've got to run there, get back to some real work in Atlanta. Thank you, sir. I appreciate your time.
Thank you, Michael.
Okay, we'll see you next time. We are going to get back to that Florida courtroom. We're going to take a quick break, come right back to the Law and Crime Network.